First Amendment to the Constitution, and in particular the two clauses,
how pleased I am
the Establishment
to
Clause
have
and
with
the
us
Free
today,
Exercise Clause,
Judge Kermit
that
Lipez,
sort of
who
come
is,
together
on
to form the
First Circuit
basis
Federal
of our
Court of
national
Appeals that sits in Boston,
values of
and who
religious
is joining us
tolerance
today to
and
speak a bit
separation of
about
church and
our
state,
First
and
Amendment to the
freedom to
Constitution,
worship and
in particular the
exercise,
two clauses,
each according to his
the
own
Establishment Clause
way.
and the
So
Free Exercise
at the outset,
Clause.
I was hoping to get a little background
Sort of come
information out of the judge, if I
together
can.
to form the basis
Judge,
of
would
our
you start just
national
by telling us where you grew up and went to school?
tolerance and
Sure.
separation of church and
I grew up,
state,
Halsey, in a
freedom
small
to
town in
worship
central
and
Pennsylvania
exercise,
called Lock Haven,
each
Pennsylvania.
according to his own way.
It's about
So at the outset,
25 miles
I was
from
hoping
State
to get a
College,
little
the home of
background
Penn State
information
University.
out of the
Most
judge if
people
I
know
can. And
Penn
Judge,
State.
would you start just by telling us where you
town of
grew
about
up
12,000
and went to
people.
school?
And that's where I
Sure.
went to high school.
I grew up, Halsey, in
and
a
basically lived
small
until I
town
went
in
off to
central
college.
Pennsylvania called Lock Haven, Pennsylvania.
And where did you go to school?
It's
to
about
college?
25 miles from
Haverford
State
College,
College, the home of Penn State University. Most
Very
people
small
know
liberal arts college just outside
Penn
of
State.
Philadelphia.
It's a town of about
When I
12,000
went to
people.
Haverford,
That's
which
where
is
I
a
went to high school
Quaker
and,
school, along with
and basically
schools
lived
in
until I went off
Lamar.
to
It had
college.
an astonishingly small
And
student
where did you
body
go to
of
school, to
450
college?
students. So it was a
I went to
very,
Haverford College,
very small school.
very small liberal arts college
Wow.
just outside
Well,
of
my
Philadelphia.
grandmother went to Swarthmore, and so did my aunt.
When I went to
And my
Haverford,
mother
it
went
was
to
a
just
Quaker
right.
school,
there.
along with schools
Yeah,
like
I'll throw
Swarthmore
that
and
in.
Lamar. It had
Interesting
an
connection,
astonishingly
sure.
small
Well,
student body of
how did you get
450
involved in
students.
law?
So it was a very small school.
Well, to some extent, it was
How
in
did
the
you get
family.
involved in law?
My father
was
was
a
a
small town lawyer, and then in the mid-50s he was appointed to the Court of Common Pleas in Pennsylvania. So he was a trial judge for a long time, and later in his career he was appointed to the Superior Court in Pennsylvania, which was an intermediate appellate court. So I had his example, which was an important one, and I knew that the law gave him a lot of satisfaction, and so I think I did not have to look very far for a model that really had an influence on my choices. So yeah, it was very much in the family through the example of my father. I went to Yale, and well, I guess to be perfectly frank, I went to Yale Law School twice because I went there the first time, and I'm not proud of this, but I think I should acknowledge it, that I went there for a week the first time and thought that this was probably a mistake. So I really, despite the example that I referred to, I did have some misgivings about law as a profession, and so I wanted to explore some other options. So I spent, I think, a very fruitful year. I did some journalism. I walked into a news clerk job at the New York Times, which was great. I then enrolled in graduate school at Penn State for half a year. I actually withdrew from Yale, the law school, got admitted to the School of American Studies at Yale, and said, I think I want to be an academic. But then I changed my mind again and crawled back to Yale Law School and said, I think I really want to stay this time. And they said, are you sure? And I said, yeah, I think so. So I went again, and this time I really liked it. And so I stayed and had 3 wonderful years at Yale. It was a great education. You know, my father was, if I were inclined and would ask him about some interesting cases, he would talk about it. He was very willing to talk about it. And so there was certainly talk about his work, both as a lawyer and a judge. But I think I felt that my choice to go to law school was a little bit too preordained for my taste. And I really, I very much enjoyed, I majored in English at Haverford, which I loved. I did feel some draw to an academic career, and I was very interested in journalism too. I had done some writing for the school paper, and I felt I needed to explore a bit I felt I had not had the opportunity to do that. And I was able to do some of that during that year in what my parents thought was the wilderness, but I thought it was actually a useful exploration. And when I finally decided law is what I wanted, I was very clear about that. And so I went back without any misgivings, and I enjoyed it very much. And so I think I should have, at the outset, not gone directly to law school. That would have been the smarter thing to do. I felt I was too much on a fixed track, and I wanted to get off it and take a look around. I think that's what I did. So it was a good year, and I encourage young folks today to take some time to look around, not feel they have to go in lockstep from one particular school to another. Look around, assess the options, and then try to make a choice. And that's what I did. So I think it was the right thing to do.
Before we move on, let me ask you, if I may, what was it like working for the New York Times? I mean, it's such an institution, if I can use that term, where it's concerned.
It was great. I mean, I did not have an exalted position. I was a news clerk. Although I must point out, that's one step up from being a copy boy or copy girl. I actually sat at a desk, and in those days, they were using teletype machines. And so all this copy would pour into my basket, and I had to circulate it in a very particular way to the editors at the copy desk. The copy boy or copy girl would pick the copy out of the basket and deliver it to the desk. I did not do that. It was fabulous. I mean, there were all these great names that I had recognized from bylines in the New York Times, and I'm sitting there listening to them talk. I witnessed the exchanges between the copy editors and the correspondents. That was not always an easy relationship. I loved it, and but I wasn't sure that I really had the skills to do that, and I thought I should explore other options. So that's when I looked at the academic option, and then that was tempting. But I was struck by the fact that a lot of the professors I saw around me seemed very unhappy with their work. It did not seem like a very happy environment. And I think I went back to law in part because, and this was always important to me, that law would give me an independence that I would not have in an academic career, for example, and that was very important to me. So that's really, I think, in the end, while I said, yeah, I think law is the way to go.
And when you say independence, what do you mean?
I mean, you have an opportunity to be more of your own boss, and this is actually, maybe you had this experience too, Halsey, I don't know, but in growing up, my parents, my grandmothers, who were aware of the vulnerability of Jewish people to the whims and prejudice of others, that to the extent possible, you should try to be your own boss so you're not vulnerable to those kind of whims and prejudices. And in my father's example, he had his own law office. He never worked for anybody. He had his own law office, and so he was independent. And as a judge, of course, you're working for the public, but you have, within the appropriate constraints of the judicial office, you have a lot of independence too. And I that was very important to me, and I thought that law offered that possibility. And when I practiced law, I practiced as a solo practitioner. I did not work for anybody. I started a law firm with some friends, so it was my own business enterprise, if you will. I wasn't really working for anybody. And I really, I mean, big firm practice can be great. It just wasn't for me. And so I wanted to be able to have that, have independence in my working life. And I thought law afforded that opportunity. And I was right about that, I must say. It did give me that option. yeah, so that was an important feature of the profession for sure.
Well, speaking for myself, independence is very appealing to me, and I would say did figure somewhat in my own professional pathway. I don't know that independence or freedom from. I didn't think of it as independence or freedom from anti-Semitism or prejudice. But I do remember distinctly feeling, for example, my own career, I went to the department right out of law school, worked for a unit of about 30 attorneys with multiple layers of review. So everything I wrote, for example, and I did get to write motions and things like that, even as a young attorney, but they were reviewed multiple times, and people would change it and change it and change it back. And what I loved, one of the things I loved when I went to the U.S. Attorney's Office in D.C. was the combination of responsibility and independence that they gave you to handle your cases. Now, I started handling misdemeanor cases, so the Republic was not at stake with anything I did, but there wasn't time. That we had so much to do. Our caseloads, we had hundreds, 150 misdemeanors. There was no time for a supervisor to review, 25 attorneys' written work, and I really love that independence.
You may have known. My first experience was with the Department of Justice. I spent a year there out of law school in the Civil Rights Division at DOJ in Washington. I do remember those many, many layers of review. I'm sure you'll recognize this term. We had to write these justification memos, the justification for what we wanted to do, and then it had to go up and up and up. And I have to admit, I chafed a bit at that. And but if I had been able to go into a U.S. Attorney's office and have the kind of independence you described, I think I would have liked that. I felt a little bit oppressed at Maine DOJ by those many layers of review that we had to pass through before we could do anything. That was I found that a little bit oppressive, I must admit.
Well, let's go back. You said that you loved law school, and what did you love about law school? Was it the intellectual challenge, the sort of give and take?
Yes, absolutely. I mean the intellectual engagement was wonderful, and I found the law fascinating, as I had hoped that I would, and there was a range of quality in the professors. They were not all great, but there were some that were really quite wonderful, and I've always been very grateful to them. I thought my classmates were great, and Yale, as you know, had a bit of a reputation as being a continuation of a liberal arts education, and I took advantage of that to some extent. So I was able to indulge some interests that were not purely law, but it was a very creative environment, and I had a good experience there. I was always very grateful that I chose to go back, and grateful that they took me back. So it was a great experience.
And then, if I understand correctly, you went from there to the department in the Civil Rights Division, which we've spoken about.
Yep.
And then, what came next? How did you get to Maine?
That's one of those. A professor from Yale, a professor named Fred Rodell, called one of my good friends in Washington. We had been classmates at Yale, to tell him that a former student of Fred's, also a graduate of Yale, had called him to see if he could suggest someone to come to Maine to work for the very new governor named Ken Curtis, who at that time was the youngest governor in the country. My friend was not interested in the job. He thought that I might be, so he called me, and I was immediately interested. I'd always been interested in politics and government. I had spent a summer in Maine as a tennis counselor at a place called Camp Kennebec on the Belgrade Lakes. I thought Maine was beautiful. And so, drawn by the combination of the beauty of the state and the chance to work for a governor and the politics, I went to Maine for an interview. We connected, and he said, "I'd like you to come to work for me." And that's how it happened. And that was the fall of 1968. And it really is the best job decision that I ever made. He was a wonderful man. Ken is very much alive. He now lives with his wife in Cape Elizabeth. He just celebrated his 90th birthday on February the 8th, and we've remained very good friends over the years. But it was quite remarkable, and he was governor for 8 years, did a lot of important work, and it was exciting to be part of it. So it was just pure good luck that got me to Maine.
What did you do for Governor Curtis?
I started as a legislative assistant. It was a small office. So I was primarily involved in the preparation of his legislative program for what was then the 104th legislative session. So I did a lot of work with the legislature. I drafted bills, I reviewed bills, I wrote about bills, I wrote a lot of his legislative messages. And then when he ran for re-election in 1970, he asked me to be his press secretary because his press secretary had left to run for the legislature. So during the campaign, I was his press secretary. And in all of those jobs, I was also his legal counsel because it was such a small office. I was the only lawyer in the office. So both as legislative assistant, I was also legal counsel. As press secretary, I was also legal counsel. And then when he was reelected by a stunning margin of 530 votes, after a recount that lasted for about 8 weeks, he asked me to be his administrative assistant for a year, actually his chief of staff. So I did that and continued to work as legal counsel. So I wore many hats, which made it particularly fascinating 3 years. It was a great experience. I left in the winter of 1971. Senator Muskie, at that time, was the front runner for the Democratic nomination for president, and so I was drawn to that campaign. I had gotten to know Senator Muskie a bit through working for Governor Curtis, and so I went to Washington to work on the campaign. So I spent a year working for Senator Muskie, and there used to be this dark humor that about the time I arrived is about the time that he began to dive in the polls. And as you were younger, but at least historically, you may know that he eventually lost the nomination to George McGovern, who ran on an anti-war platform. Muskie had supported the war. That became a huge and divisive issue in the Democratic primary, and McGovern ended up winning quite handily. So it was not a happy experience for Senator Muskie or those of us working for him. But again, it was fascinating to be exposed to the national politics, and when he left the campaign trail, he came back and worked in the Senate. So I actually spent a lot of time as a traditional legislative aide for Senator Muskie. I got to spend time on the Senate floor, because you could go there then to give advice to your senator. And so it brought back a lot of memories to me, Halsey, when January 6th came and I saw these rioters marauding around the Senate floor that I used to work on. It was, like all of us, I could not believe what I was seeing, but actually seeing them there on that floor, knowing how carefully guarded it was just astonishing to me. But I did that for a year, and then Ken Curtis and I had talked about starting a law firm when he left office. He was going to leave in January of 1975, so I came back to Maine. We knew that none of us really knew how to practice law, so I opened a solo practice on 85 Exchange Street in Portland. And I was a solo practitioner for about a year and a half, a year and 3/4, which was great. I did a little of everything. Then we started a we opened a law firm. There were three of us. And one of my partners was someone whom you knew very well. That was Walter Corey, who sadly passed away very recently. And I know that you had gotten to know Walter pretty well in later years. And so the three of us started a law firm, which today is the firm of Curtis Thaxter. So that's how that came about.
How did you become a judge?
Well, I enjoyed private practice. I had done it between my solo practice and the firm. I had done it for about 10 or 11 years at that point. And I guess my father's example was probably important, Halsey. And I also, I think and I know you can identify with this because I think this is in part a choice you have made. I love working in the public sector. I found it, to be honest with you, more satisfying than private practice. And yet I did enjoy the law. And for me, becoming a judge was sort of the perfect marriage of public sector work and engagement with the law. And so through good fortune, and I've always been very grateful to him, Governor Brennan nominated me for a position on the Maine Superior Court, which, as you know, is our trial court. And so that was in 1985. So I was nominated to the Superior Court, was confirmed, and I spent 9 years as a state trial judge. Yep. Which was great experience. I loved it.
Let me stop you and just ask you, what does a state trial judge do for the benefit of our audience?
Sure. Well, we called ourselves the Court of General Jurisdiction, which meant we did everything. By everything, I mean we did civil work, criminal work. All the jury trials were conducted in the Superior Court. And we did, on the criminal side, range from, I tried many, as we call it in Maine, operating under the influence charges to murder charges. We don't have capital punishment in Maine, but so it was the full range of criminal work, and on the civil side, very simple fender benders to very complex multi-party litigation. So it was, I think, one of the pleasures of being a judge in an age of specialization is of necessity. You have to be a generalist. You have to do whatever comes your way, and that was a very appealing part of the job. And I really enjoyed the endless variety of the work. And I mean, all trial judges will tell you, and I know you know this from your own trial experience, Halsey, working with juries is really quite wonderful. And so it was really, I really enjoyed that part of the job a lot. So it was, those were nine great years for sure. Yeah.
Sometimes I've found juries to be perplexing, I have to say, but.
Well, I will say quickly, Halsey, it is a myth that they always get it right. They do not. I mean, it's a wonderful institution, but we should not romanticize it. They do not always get it right.
No, I'm a big fan of the trial process as a mechanism for determining truth and doing justice, so I don't mean to suggest otherwise, but sure. I've also had experiences where I was left scratching my head to understand their decisions. Well, so you did that for 9 years, and what next?
I was then nominated by my politics, as perhaps you can tell, had been in the Democratic Party, but through a happy set of circumstances, I was nominated to the Maine Supreme Court by Governor John McKernan, a Republican, and I spent 4 years there. I mean, I love that work. People will sometimes ask me, what did I prefer, the appellate work or the trial work? And I can say, in all honesty, I love them both. I don't have a preference.
What does an appellate judge do for the benefit of our audience?
Right. Well, as an appellate judge, you review the work of the trial courts. So you're not engaged in the trial work, which consists of the presentation of evidence, decisions by juries. You are there as an appellate judge to make sure the trial process was as error-free as possible. So basically, you are reviewing the record of the proceedings below. And so, it does not have the, I guess you could say, the drama, the immediacy of the trial court. It's a more cloistered type of work. You're working with your colleagues because as an appellate judge, you alone do not make the decision. On the Maine Supreme Court, there were 7 of us, so 7 of us would be reviewing the work, and we had to make the decision. And so you spend a lot of time researching and writing. That has enormous intellectual satisfactions, but it's a different kind of satisfaction for sure. But it's an attempt to make sure that in the end, the process has been as fair and legally correct as possible. And that's what appellate judges are there for, to make sure it's as fair and legally correct as possible before there's a final judgment, before somebody has to spend many years in prison, before somebody has to pay an enormous amount of money. We want to make sure that the decision was as correct as we can possibly make it.
And if I can, I'd like to spend a little more time just pursuing, how does the process work? So there's a decision below, maybe it's a jury verdict, a sentence, and one of the parties isn't happy and they appeal to you as the appellate court?
That's correct. That's right.
Correct?
We get briefs from parties on both sides of the case, and we obviously review those. And then in most instances, there'll then be an oral argument where the judges have an opportunity to ask the attorneys questions about the case. It may be from reading the briefs. We have particular concerns, so we have an oral argument in the hope the attorneys can address those concerns. And then after the arguments, the judges have a conference. And on the Maine Supreme Court, there were 7 of us, and we would then confer, and we would take a vote. You literally would go around the table, starting from the most junior justice up to the chief justice, and each one of us would state our position on the case. And the majority vote would determine the outcome of the case. Many times we were unanimous, but at times we'd be divided, and we could be divided 4-3, 5-2, 6-1. But the majority vote would prevail, and that would become the decision of the court. And then one of the judges would be assigned to write the decision. In writing the decision, it would be circulated to the other members of the court, who would then review the decision. And eventually you would agree on a decision which became the decision of the court. And the theory is, and I think it's a sensible theory, is that a collective body has a better chance of getting it right than even just 1 or 2 judges. And so the hope is, on the Maine Supreme Court, with 7 people looking at the case, hopefully that collective deliberation will produce a fair and correct result. And it was it's a fascinating process. Obviously, we did not always agree, but even our disagreements, for the most part, would be amicable. And I think it's not perfect, but I think it's quite a good process. And its basic purpose is to avoid, so much as humanly possible, error in the process, so that in the end, the correct result has been reached.
Now, you were on that court for 4 years. Do I have that right?
That's correct. Yeah, that's right.
And where did you go next?
I then got the job that I now have. This is 1990, April of 1998. President Clinton nominated me to be a judge on the First Circuit. That process had actually begun, a year or so earlier, but it's a long process. But President Clinton nominated me in the spring of 1998. I was confirmed by the Senate, and I started this job July 1 of 1998, and that's when I started this job.
And that's as a federal appellate judge on the First Circuit that sits in Boston, correct?
That is correct, yes. And As you well know, please go ahead.
I'm sorry. How is that different from the appellate court in Maine?
Right. The Maine Supreme Court, as the name suggests, is the highest court in Maine. The court on which I now sit is called an Intermediate Court of Appeals. We stand, if you will, between the trial court and the United States Supreme Court. If there's to be an appeal from our decision, it can only go to the United States Supreme Court. And as you well know, the Supreme Court, it's a certiorari court, which is just a fancy way of saying they hear only those cases that they feel require their attention. They're not there just to correct errors in the lower courts. They're there to decide really large issues that affect the way in which the lower courts operate. They're there to decide really momentous issues. We on the Court of Appeals, we are really more akin to the Maine Supreme Court in the sense we're there to correct errors. And most of the law in the federal court does come from the courts of appeal. I mean, we collectively, the courts of appeal from around the country decide thousands and thousands of cases. The Supreme Court currently may decide 75 or 80 cases a year. So most of the federal court decision-making does come from the courts of appeal.
And before we leave the subject, so the federal system is somewhat different, separate, and apart from each state systems.
Yes.
Correct.
Absolutely.
It has its own parallel system of trial courts called district courts, intermediate appellate courts like the one you sit on, and then the ultimate Court of Appeals, the Supreme Court in Washington, D.C.
That's correct. Absolutely. And there is a vast body of federal law. As a state court judge, I did not see much of that. I was dealing with the laws of the state of Maine. In the federal court system, for the most part, there is an exception called diversity jurisdiction, which you don't have to get bogged down in. But for the most part, we're dealing with federal law, which is obviously a vast body of law. But that's a major difference. We have speaking generally, two parallel legal systems in this country. The state system with all the individual laws of the states, and then the federal system, which is an entirely separate body of law.
Well, let's maybe move from there. And if I could ask you, and again, if you're willing, would you describe for our audience the role, if any, that religion has played in your life?
Sure. Well, if you had to give it a label, I grew up in a conservative Jewish household. We were not Orthodox in the sense that we scrupulously obeyed all of the religious laws. The Reform movement had not really taken hold, so we had what was called a conservative congregation, which a lot of the service was in Hebrew, but we were not expected to keep kosher, to worship every day, to observe the Sabbath faithfully. So it was a serious but not all-consuming part of our lives. I was bar mitzvahed. We observed the traditional holidays, Hanukkah, Passover, the high holidays. And it was a significant part of my life. Although I have to say that I was somewhat resistant to it. I was not a good Hebrew student. Somehow I did not like it. And I actually didn't win. I came in second place in a writing contest sponsored by Barton Candy. I wrote an essay called The Lazy Hebrew Student, which where I engaged in a little bit of self-examination. I got a year's supply of Barton candy for it, but I had to be tutored, especially by the rabbi, to get ready for my bar mitzvah. I, it was not. I did not happily engage in that part of my life, but I knew it was important to my parents, and I did it. And to some extent, I've continued to be I guess I would say a loyal Jew, but not a closely observant Jew. And my wife is not Jewish. She converted. We raised our children Jewish. And the traditions are very important to us. I mean, I'm proud of my Jewish heritage. I'm grateful to the ancestors who made the difficult journey from the old country to the new and gave me the opportunity to have the kind of life that I've had. And we continue to be observant, really, in the ways that I was as a child. We observe the holidays. Our grandchildren are being educated as Jews, and it continues to be an important part of our lives, but I guess it's not as central as it is to some others. Perhaps I have some regrets about it, but that is the reality. Important, but not central in our lives.
All right. Well, I think at this point we're probably ready and maybe ought to turn to the subject at hand before it's too late, and sure. That being as I describe it for this initiative, the source, some understanding of the source, origin, and meaning of our national value of religious tolerance. In the first instance, as embodied in our First Amendment clauses, the Establishment Clause and the Free Exercise Clause. The Establishment Clause providing that Congress shall make no law respecting an establishment of religion, and the Free Exercise Clause providing that Congress shall make no law prohibiting the free exercise of religion, which I think of as sort of combining to produce some of these concepts I've alluded to, and as well as the separation of church and state, the idea that our government should be neutral towards people's religion, should permit people to practice their religion, should avoid infusing religion into secular government, and certainly avoid government oppression of religion, avoid the conflicts that in history have been inspired and animated by religion. And Judge, by way of explanation, I've asked you if you would offer your perspective on this topic for a variety of reasons, because I think you are so thoughtful, and I know you've made this subject one that you personally have studied, and I happened, and I'll now promote I happened upon your, just by coincidence, the article that you published in the Maine Law Review last year, Reflections on the Church-State Puzzle. So if I could ask you, if you might, for the benefit of our audience, talk a little bit about the background and history of those two clauses in the First Amendment, where they came from, the context in which they were written and ratified?
Sure. Well, I guess to do that, Halsey, I'm going to have to paint in some fairly broad strokes. But so why don't we start in the say around the 5th century and cover like 1,000 years in Europe. From the 5th century into the 16th century, the Catholic Church dominated Europe. Dominated every aspect of life. Beginning in the 16th century, there was a reaction against that, the well-known Reformation led by Martin Luther. That created some religious conflict. It was abetted by history in England, which is very important to the background of our Constitution, when King Henry VIII, frustrated when the Pope would not grant him a divorce, he effectuated a schism from the papacy and established the Church of England, and he was the head of state, the head of church. That added to some of the religious conflict in England. There were groups who felt the Reformation had not gone far enough. They were unhappy with the Church of England. And he created groups, most well-known of which would be the Puritans, who were persecuted for their religious beliefs. To escape that persecution, they came to this country and established, primarily in Massachusetts, a colony where they could practice their religion. Ironically, although they were the victims of persecution, they were not religiously tolerant. And they practiced against Quakers, Jews, Catholics, some of the persecution they had experienced, forcing members of those religions to go to other colonies. And so you had a long history in Europe of religious persecution. Although some of the victims came to this country to escape that, they perpetuated the persecution here. And that really continued. And this is really, I think, a critical moment in the history of our constitutional provisions. That history came to I guess you could say, a climax in Virginia, which was the birthplace of two of the most important members of our founding generation, James Madison and Thomas Jefferson. And in Virginia, there continued to be a debate about the role of government in the religious affairs of men and women. And in 1784, Patrick Henry of Give Me Liberty or Give Me Death fame introduced a bill that would provide for state support for Christian education. People would be taxed to support Christian education. And James Madison and Jefferson, heavily influenced by the English philosopher John Locke, who was a sharp critic of the Catholic Church, who believed very much in separation of church and state, heavily influenced by him. They had studied Locke in their education. Strongly opposed Patrick Henry's initiative in the Virginia legislature, and they defeated it. And then Jefferson, in the wake of that, introduced a bill that would provide for religious freedom in Virginia, and which would make clear that there would be no state-established religion in Virginia. They were successful in that. And then Madison, with that experience behind him, went to Philadelphia very much determined to replicate in the federal Constitution the Virginia experience. In other words, very committed to the concept of separation of church and state, and also the free exercise of religion. Initially, as you know, the Constitution did not include a Bill of Rights. The only reference to religion in the original Constitution is in Article 6, where there is a provision that there cannot be any religious test for the holding of public office. But that was sort of emblematic of their view that religion and the state should be kept very separate. But even that provision was not satisfactory to a group of individuals known as the Anti-Federalists, who were very concerned about a very strong central government. And some of the states, in ratifying the Constitution, made clear that they were doing so on the expectation that there would be a Bill of Rights that would protect the states from an encroaching federal government, that would enshrine the rights of the states and the individuals within the states, certain rights. And Madison, even after the ratification of the Constitution, which was ratified by 9 of the 13 colonies, I think it was 1789, he set about to follow through on the promise that there would be a Bill of Rights. And he was the principal drafter of the First Amendment, and replicating that experience in Virginia, and very concerned that we not repeat in our country the kind of religious persecution and conflict between church and state that had taken place in Europe and in the early colonies. He drafted the religion clauses, which you quoted earlier, and they became part of the Bill of Rights. Now, importantly, as you noted when you quoted it, the Bill of Rights is directed at Congress. It tells us what Congress cannot do. Originally, Madison hoped to make the Bill of Rights applicable to both the federal government and the states. He did not succeed in his attempt to make the Bill of Rights applicable to the states. In the end, the Bill of Rights became a kind of a sort of jurisdictional status quo provision, in the sense that it applied only to the federal government and not to the states, and not to diminish its significance. That was certainly important, but it became a limitation only on the federal government and not on the states. And historically, that's quite important.
But eventually it does get extended to the states, correct?
That is correct, yes.
It takes a while, although in the larger scheme of things, maybe history was accelerating slightly.
Yeah, formally, I mean, for real, it took place in the 1940s, and it was done by the Supreme Court, and they did it by a process of incorporation. One of the Reconstruction Amendments, that is referring to the amendments that were adopted in the wake of the Civil War, was the 14th Amendment, which made the Due Process Clause of the federal Constitution applicable to the states. And through a process of incorporation, the Supreme Court in the 1940s incorporated both the Establishment Clause and the Free Exercise Clause into the 14th Amendment, thereby making them applicable to the states. And it's really when those clauses became applicable to the states that you really begin to get the judicial evolution of those clauses. We begin to get cases which really implicate the Establishment Clause and the Free Exercise Clause. And that's really when that development of the law begins, because initially the clauses applied only to the federal government. There were a lot of, frankly, oppressive religious measures enacted by legislatures in the states for a long time. There was a lot of ugly stuff going on in the states in terms of religious persecution for a very long time. I mean, if we are honest with ourselves, Halsey, in terms of our religious history, it has not been a pretty picture. I mean, there's been a lot of religious oppression in our country, very harsh treatment of religious minorities. And our tradition of religious tolerance is a very mixed tradition. We have a lot to atone for today in terms of the way we treated religious minorities in the past. There's no question about that.
And there's so many opportunities for entanglement between the two, and states, at least historically, were pretty active in that regard. I mean, government buildings, as we may get to in minutes, with religious iconry and inscriptions, government monuments with religious aspects, government, as you've mentioned, support for various forms of institutions with religious aspects like schools, government regulating religious activities. There's a lot of opportunity there. And those issues, as we've discussed, I mean, they continue to percolate to this day, including here in Maine with issues about state support of religious schools, COVID restrictions on church services, just to mention two that have been in the news recently.
Absolutely. Yeah, these are not, these are not intellectual exercises. These are real world problems. There's no question about it. Absolutely.
And over the same period of time, the law has been evolving and developing.
Absolutely. That's correct. I mean, I was drawn to this church state subject because, yeah, I mean, it's intellectually fascinating, but it has real world effects, and the kind of cases you described demonstrate the immediacy of these problems. And it's a particularly active body of law today because the Supreme Court I think it's fair to say, has set about to change some of the traditional religious doctrine in this area. And it seems that in every term of the court, there will be one or two decisions with very large implications for the relationship between church and state in this country. So this is a very live issue of very large consequences for all of us. No question about it.
Well, I thought, as we discussed in preparation for this episode, that we might focus on two cases to illustrate the points. And before we do, I thought it also might make some sense just to talk about that sort of method that gets used in law school, known as the case method, the Socratic method, as a way to sort of explore issues and build understanding. The case method, the idea of focusing on a particular case and a particular set of facts in order to better understand the issues at stake. And then, as I recall it, it was still practiced. I don't know if they're still using the Socratic method in law school, but they did when I went there. And I'm not going to admit how long ago. All right, it was the early 80s. But in which the teacher would ask the students questions about the cases, and if they were a good teacher, they were good at asking questions that would, and you were a good student and you had read the case, ask questions that would draw out those issues and engage the class in useful sort of discussion. And having said that, how about if we talk about Goldman versus Weinberger?
Sure.
The 1986 Supreme Court case that focuses on the free exercise clause of the First Amendment. And
Sure.
I should probably say that Weinberger, he was Secretary of Defense at the time, correct?
That's
I
correct.
hope I have that right.
That's right. That is correct. You bet. Yeah.
And Mr. Goldman was in the Air Force, if I understand it.
That's right. Yes, we always, as you and I know, you always start with the fact. That's how you can understand the case. Yeah, I think that's an interesting case because it does illustrate how these very general, in this case, the free exercise, how a very general doctrine plays out in the real world. And yeah, the plaintiff, Mr. Goldman, he was a mental health professional with a military career. In carrying out his work, he was obviously an Orthodox Jew. He always wore a yarmulke, and he wore it both when he was in the hospital. He wore it on the outside, and at some point, another member of the military who had seen him as a witness in court complained that in wearing his yarmulke, he was not complying with the military dress code. And that ultimately led to an order to him that he stop wearing the yarmulke. And he challenged that in court, claiming that by refusing to allow him to wear a yarmulke, he was being denied his free exercise right. And that became a case that traveled all the way to the Supreme Court. His position was that as an expression of his religious belief, as part of his religious life, he should be able to wear his yarmulke, despite what the military code said. And that was
Let me stop you for a minute, and just for the benefit of our audience, and they may all know, but what is a yarmulke or a kippah?
Yeah, it's called a skull cap. It's a small cap that sits on the top of the head of a worshiping Jew. For many members of the Jewish community, it is only worn during the religious service. It is a sign of devotion and obedience to God. But there are other members of the Jewish community who feel that that kind of devotion should not be shown only in a house of worship. It should be a continuing part of their lives. And so they wear it at least they wear it in public for sure. I don't know whether it's worn at home as well. It probably is. But for more Orthodox Jews, it is an important part of their religious life to wear the yarmulke. And interestingly, I had not thought of the yarmulke in these terms, but in the opinion that we're going to talk about, Justice Stevens, in writing what's called a concurrence, he referred to it as a symbol, as a statement against anti-Semitism, that when Jews wear it publicly, it is a proud statement of their Jewish identity. I think when people see somebody who's Jewish wearing it in public, they know that they're Jewish. And I think for some who wear it, it is a proud public statement of their identity. And in that sense, it's seen as a challenge to anti-Semitism. But for the plaintiff in the case, he felt strongly that he should be able to wear the yarmulke, and it did not in any way detract from the work that he was doing. And that became the issue in the courts. And it worked its all the way up to the Supreme Court.
I'll interrupt again just to observe for the benefit of our audience an interesting parallel here, which is that in another episode of this initiative, I interviewed the Attorney General of the state of New Jersey, who is a Sikh. His name is Gurbir Grewal, and he wears a turban all the time, or at least most of the time. And that is an article of clothing that is associated with his faith, as well as others. But I interrupted you. Okay, so Mr. Goldman believes that this order has infringed his First Amendment right to freely exercise his Jewish religion, and he sues to challenge that order. As I understand it, the trial court, the district court, enjoined the Air Force, told the Air Force that it couldn't enforce the order against him, but the Court of Appeals, that would be your level court, reversed that, and that set the stage for it to go to the Supreme Court.
That is correct. And the Supreme Court, it's not a unanimous decision, but nevertheless, the Supreme Court, in a decision written by then Chief Justice Rehnquist, said that without minimizing Dr. Goldman's sincerity in his belief or his strong view that he should be allowed to wear it, the court said we really need to defer to the military. And in law, this concept of deference is very important. When courts review decisions by the government, the outcome often turns on how much deference the court is willing to give to the government. And in this Goldman decision, the court said that deference is particularly important when the court is reviewing a decision of the military, which after all is responsible for our national defense. So how does the wearing of a yarmulke implicate our national defense? Well, the court said the Army, it's the Air Force in this case. In any event, the military says that we have to maintain discipline in the ranks. Uniformity of dress can be an important way of instilling discipline. And if we are not allowed to insist on some uniformity, we may get some individuals who want to wear the yarmulkes. You just referred to the Attorney General of New Jersey. They actually talked about the possibility that others will want to wear turbans as an expression of their religious views. Where does it stop? Is the military going to have to examine the sincerity and the importance of every religious belief? That would be unworkable. So the military says, as part of the need to instill discipline in the ranks, we must have the right to establish a uniform dress code. And that's what the Supreme Court said. They deferred to the military. The dissenting judges, particularly Justice Brennan, he said, look, if the military thinks it is so important to the perpetuation of discipline, if they be allowed to have a uniform code. Show us, give us expert testimony. Don't ask us to accept it on faith. And the majority said, look, we're not going to ask the military to explain to us why their discipline would be threatened if they cannot insist on this uniformity. In effect, we're going to take it on faith. We're going to defer to their judgment that it's necessary to preserve this uniformity. And so Mr. Goldman lost. But interestingly, he didn't lose without a real fight. I mean, our legal system allowed him to carry his grievance, his insistence that he be able to exercise his religious rights all the way to the highest court in the land. And only after that protracted fight and a reasoned decision did he lose. So yeah, he lost, but he lost through a judicial process that certainly took his insistence on religious liberty seriously. And so even though the outcome was a disappointment to him, I don't think he could ever say that he did not have a full opportunity to air his views and get his religious liberty objection considered very seriously. So I think it's a good example of how the free exercise clause plays out in real life.
Now, the dissenters were pretty critical of the majority arguments, including the idea that somehow our national security was jeopardized by what kind of headgear somebody in the Air Force wore. And you've already talked about how they argued we shouldn't be so deferential, uncritically deferential to the military, and pointed out that there was no support in the record of any demonstrated threat to discipline or order, and furthermore that it seemed to defy experience and common sense, and maybe even be inconsistent. The Air Force apparently tolerated some other items of personal apparel, even those that were symbolic, had religious symbolism, such as rings and identification bracelets.
No, that's absolutely true. I think that it's a fair point to make, Halsey, that people of strong views and good faith can disagree on these issues. These are not easy issues, and but in the end, a decision has to be made, and the majority, this is an example of majority rules. If a majority of the judges come out in one way on the case, that becomes the law of the case. It's interesting to talk about the dissenters' views, but in the end, that's not the law. The law is what the majority says it is. And in this case, the majority sided with the military.
Although it wasn't the last word, as I understand it, correct? Because didn't Congress go on to pass a law?
Exactly. And I think that's really an important point to make, Halsey, that there is a role for the legislature in protecting minority religious rights. And you're absolutely right. The legislature, perhaps feeling that this was not a just outcome, they changed the law to allow for more flexibility in the dress code. And at this point, all the court was saying was the free exercise clause does not compel us to rule that the military could not insist on this uniformity. But just because we say the Constitution doesn't compel it, that doesn't mean the legislature cannot permit it. And so the political branch went to work and arrived at the solution that you described. So that demonstrates the interesting interaction between the courts and the legislature. And if the court has not constitutionalized something, by which I mean hasn't said it has to be this way as a matter of constitutional law, then there's room for the legislature to bring its judgment to bear on the subject in the way that you described. So it is an interesting example of the way the courts and the legislature interact.
Well, the other case that you suggested we discuss is the 1989 case of Allegheny versus the American Civil Liberties Union. This is an Establishment Clause case as applied to 2 winter holiday displays in government buildings it was Pittsburgh, wasn't it?
That's correct.
Pittsburgh, I think.
That's right. Yeah.
One was a Christmas nativity or creche scene in a courthouse under a sign, which I take it was a sign that was owned by the Roman Catholic Church there in Pittsburgh, and the sign read "Glory to God." And that the other display, and this set up a nice dichotomy for the court to work with, was a sort of combination, a very large Christmas tree, a relatively smaller menorah, and we probably ought to explain what that is, and a sign saluting liberty, all in the county, the Allegheny County office building.
Correct. That's right.
And as I understand it, the American Civil Liberties Union sued, claiming that both of those displays violated the Establishment Clause prohibition on government established religion.
Right.
It might make sense just to explain a little bit what a menorah is, in case some of our audience isn't familiar. They probably are, but
yeah, well,
it's a candelabra.
That's how I would describe it, Halsey, and it is used at Hanukkah, and it memorializes the miracle of the Maccabees, who I'm probably going to get this wrong. You may know the history better than I do, but who, in order to commemorate, I think, a great victory over maybe the Assyrians, they wanted to light some candles, and they could only find a tiny bit of oil, which wasn't going to burn for very long, but miraculously it burned, I think, for 8 days and nights, and so the menorah sort of symbolizes this great victory of the Maccabees over the Assyrians. It's viewed as a symbol of religious freedom. I mean, that's really what in winning that great victory, the Maccabees had protected the rights of the Jews to live as free people and to worship as they wanted. And so in our religion, it's a great symbol of religious freedom. I think that's the importance of it.
All right. So the ACLU sues, and the district court, as I understand it, denied the injunction. Wouldn't say you got to stop. You got to strike these displays. But the Intermediate Court of Appeals reversed that decision and held that whatever their purpose, both of these displays had the effect of improperly, unconstitutionally endorsing religion. And so at that point, it goes up to the Supreme Court, and it's another one of these close decisions, as you've so eloquently explained. I mean, these are difficult, complicated issues, and I think tough to decide.
They're very tough to decide, and I guess to use a colloquial expression, the Supreme Court sort of split the baby on this one.
I know. I thought about using that as well.
Well, maybe I shouldn't.
Anyway,
I think it's probably a fair description. Yeah. So as you've described, there was in the county, in the courthouse, there was this display of a creche, a nativity scene, underneath a sign that said, it was actually in Latin, Gloria in excelsis Deo, or glory to God in the highest. The court looked at that and said, look, given the prominence of that display, its unmistakable Christian theme, the creche and the sign, someone looking at that, and they don't quite put it this way, but they're saying, a member of the public looking at that would say, the government, this is after all a public building, the government appears to be endorsing Christianity as an official state religion. And the Establishment Clause is all about not having an official state religion. This would seem far removed from actually proclaiming that, in this case, Christianity is the official religion. But the concern is that members of the public could read it that way, could see it as an endorsement. And for those who are not Christian, other minorities might feel they're being excluded by the government because of this singular recognition of the Christian religion. So the court, applying what you described correctly as this endorsement test, said that this is going too far. This really does violate the Establishment Clause. On the other hand, at another public building, which was the city-county government building, you had a sort of mixed display. You have the Christmas tree, you have the menorah, and that sign of liberty. Now, importantly, the court did not say because there's what could be viewed as a Christian symbol and a Jewish symbol, that's okay, because it would not be appropriate for the government to say, well, we endorse both Christianity and Judaism. That doesn't make it all right. Endorsing two religions as opposed to one doesn't avoid the Establishment Clause problem. What they did, they said, look, when you put all this together, these are just symbols of the holiday season. This is really a secular display, not a sectarian display. And because it's secular, and because it will be seen as secular, it does not run afoul of the Establishment Clause. So that's how they split the baby. And today, while this case may resonate with a lot of people, I mean, you do see at the holiday season, you will see displays, but they're often done in recognition of this kind of ruling. I think very often you'll see a mixed display which does not run afoul of the Constitution. I don't think you would ever see, I guess I shouldn't go too far out on the limb, but I don't know that you would now see just a creche on a public building or just a menorah. You're apt to see a kind of mixed setting, mixed scene, which is viewed as a celebration of the holiday season and not the endorsement of any particular religion. So, that's an example of the Establishment Clause in play, and a concern that our government not act in a way that would be seen by religious minorities as excluding them from the governmental embrace. And that's a very important concept, and I think it again demonstrates how these very general clauses play out in our real and daily lives.
I maybe should also say that a creche is a nativity scene recreating the birth of Jesus in a manger.
Correct.
Just for equal treatment there.
Yes.
And what I was struck by in this decision was just how deep into the weeds the Supreme Court goes in analyzing the details of these two displays in its effort to interpret or to understand the message being conveyed and whether or not it improperly promotes religion or entangles government with religion or maybe discriminates between religions. They really there's a lot of back and forth in the opinions about that, I think.
Well, that's right. I mean, they always say context matters, and so they're trying to, they're trying to explain how, although they don't always put it this way, how would members of the public perceive these scenes? Would they see it as an endorsement of religion or something else? And not to get into the weeds, Halsey, but I have to acknowledge there is some question today whether this endorsement test is still the law of the Supreme Court. It may be being replaced by a focus on, so what is the history behind these kind of displays? And if the history is anchored in certain traditions, maybe the history should prevail rather than this endorsement test. So it's in the law, at least, it's a bit of a subject of debate, but at least in the decision we've been discussing, that endorsement test was certainly front and center in the decision.
Right, and you've alerted to this evolution in the Supreme Court's thinking. Recent developments sort of headed in that direction earlier, I think.
Yes, no, that's correct. Just as I hope a somewhat useful generality, I think it is fair to say that the modern Supreme Court, which I think reflects a view that there should be greater room for religion in our public lives than the doctrine currently allows, is trying to de-emphasize the Establishment Clause, which has been seen as an impediment to the acknowledgement of the importance of religion in our public lives. Has been de-emphasizing it in favor of a more aggressive application of the Free Exercise Clause as a way of furthering the role of religion in our public lives. And that's a debate that is now going on the Supreme Court. I have written a bit about that, and it's worth watching. I think folks who want to follow the evolution of the law will see that play out in cases before the Supreme Court. And just very quick, there's a fascinating case before the Supreme Court now, in which the court is being asked to rule that an anti-discrimination law in Philadelphia does not preclude a particular social agency from refusing to certify gay couples for the foster care of children. And so there's a huge debate now about the tension between our anti-discrimination laws and the free exercise of religion. So this again is a very current and important topic that continues and does bear watching.
Well, Judge, on that note, I'd ask if there are any additional or concluding thoughts you'd like to share at this point.
Well, none other than really applauding you and those who are sponsoring this program for undertaking this effort, which, as I understand it, generally is designed to address the ongoing problem of anti-Semitism. It's an enormously important subject, insufficiently understood, both historically and in its immediate impact. And so I applaud you and the sponsors for doing it, and I'm very grateful to you for allowing me to be part of this very important initiative. So thank you very much for this opportunity.
Well, thank you, Judge. The gratitude is mutual. I really appreciate your taking the time to speak with me today about these issues, and I think that this discussion, I hope, will be well received. And thank you again.
Thank you. Thank you, Halsey. Great to be with you.